work program of the convention, we have quite specific indications and suggestions about adaptation or ecosystem-based adaptation. And we see there are a lot of different approaches. Some are procedural, but I think compared to what we see in the climate change regime, also some of them are substantial and really provide for details as to what countries can do in looking at their ecosystems and species and genetic resources and try to address adaptation issues. So we have indications about the role of farmers and conservation of traditional and local varieties. We have questions related to restoration of ecosystems in mountains, for example, the establishment of corridors among different sensitive habitats or protected areas, the importance of early warning systems, and again, impact assessment, but also uses of strengthening laws on sustainable use of waters, looking at land use planning and coastal zone planning, and looking then at specific capacities of different either species or ecosystems and taking that on board in devising specific adaptation strategies. So quite a wealth of information that once again is perhaps fragmented in different decisions, but it brings a very complex and rich picture of the inputs of the Convention on Biological Diversity on the work, on the global agenda on adaptation. Looking therefore, mostly focusing as opposed to the work on adaptation of the climate change regime on the opportunities for natural adaptation and the opportunities for restoring natural ecosystems in a way that contributes to adaptation. So if you can ask Ben to go to the next, please. Thank you. Now, in the context of the Convention to combat desertification, again, we have some original text and ideas that very much speak to what we're going to discuss today. So already, for example, the very definition of desertification already links climate change and livelihoods. And there is quite a clear link in the text of the Convention about adaptation, sustainable land management, and food security. So very important links that go to the idea of looking at communities, of a bottom-up approach to adaptation. And the more recent work of the Convention has focused on those links and has developed them in a way that allows, again, for more clarity about what national legislation or at least national action should be about. So looking at how adaptation can be achieved in terms of creating appropriate food security systems, looking at devising alternative livelihood projects, and sustainable irrigation programs. Now, this has been very much going on in the context of national action plans. Again, a planning obligation for parties to the Convention. But I think one of the interesting findings of the work that my colleagues have undertaken is that while these plans have very important ideas enshrined in them, they haven't yet achieved as much impact on the ground, in part because they have been very timid in suggesting necessary legislative reforms and incentive and institutional reforms. So something that should very much, I think, come up in our discussions today again. But what we see is also that the Convention is actively looking for entry points in the work of the climate change regime. And part of its work, for example, an advocacy framework, is to specifically identify within the outcomes of the discussions in the climate change regime links to the objectives of the Desertification Convention, and therefore making those links that exist clearer and more action-oriented for parties. If you can ask to move to the next, which is our penultimate slide. I think two of the important elements that have emerged from this work in looking at the three Rio Conventions is that, well, clearly all three conventions require for very important planning obligations for parties. If at the national level we are able to synergize with these efforts, which are very time-consuming and resource-consuming, this is probably one of the key, most immediate ways to ensure building on the rich information and complying with the international obligation in a way that achieves adaptation throughout the Rio Conventions. And I think the other important finding is that funding can also be critical in really linking the national efforts to implement the different three conventions towards adaptation. And already on the ground we are seeing that both in the context of the Global Environment Facility, but also the work that is being undertaken by the Global Mechanism for the UN Convention to Combat Desertification, opportunities for funding, for attracting climate funding and addressing issues also protected by the Convention on Biological Diversity and that on desertification are possible, and they should actually be more and more systematically explored with a view to implement in a synergistic manner the three conventions. If you can look to the last, thank you. So the very last slide is really about the role of national law into this. We see that there's a lot of ideas and stronger linkages between the conventions, but it may not always be obvious where and how much national law and lawyers are needed. And we have started with a comparative work looking at different laws in different regions and seeing how these ideas and opportunities that have been highlighted or created at the international level can then be materialized and grounded at the national and local level through legislation. And I've mentioned already earlier on that environmental impact assessment is, for example, an obvious candidate for critical work by national lawyers. Adaptation mainstreaming can really start from environmental impact assessment, and legislation can be crucial, for example, in ensuring and requiring the specific expertise related to climate adaptation is built-in impact assessment processes, and also providing for specific requirements for adaptation issues to be taken into account at different levels within the impact assessment process. Another very challenging aspect of national law is that of moving away from being inflexible and removing some of those barriers that were mentioned at the very start of our session, and instead embracing a flexibility that very much reflects adaptive management. So the idea of continuously looking for information, adapting decision making to that information, monitoring implementation of laws, and on the basis of what is learned from that then revisiting certain regulatory approaches with a view to gradually moving towards adaptation. So it's really the idea of regulating by information, building our laws, not so much having in mind very strict and stable requirements that may collapse in the faces of the changes brought by climate change, but rather finding ways in which regulation can be a living instrument that informs and is informed by adaptive management. Another very important element of national law is that of thinking of how this flexibility can then be built in the context of private sector operations, looking at ways in which the private sector may be made responsible for providing on an ongoing basis information about adaptation, monitoring and contributing to the work of the government in that respect, but also looking at some of the inflexible instruments that we can find in terms of licenses and concessions, very long-term instruments that may provide for certain rights for the private sector, but that may at certain points reveal themselves obstacles in the work of governments vis-a-vis climate changes. And so the idea is that in some jurisdictions at least, that of using reopener clauses, so clauses that allow for renegotiation of certain elements of those licenses and concessions with a view to creating some flexibility for the government to take into account changes and readjust the conditions for the operations of private business. We have looked also at the role of national courts, and of course while that may be very important, we have a question mark there that clearly courts come in at a stage where perhaps it may be either, it's a sort of a reactive approach to adaptation, and clearly our efforts have been focused on proactive and precautionary approaches to adaptation, so looking more at how laws are devised and applied rather than looking at the role of courts. But that can still be a very important element in the legislative dynamics in a country. But overall, I think one of the final findings, which I think links back to the importance of MEA synergies, is that for effective national legislation, institutional cooperation is essential. It's something that can be promoted by legislation, but also needs a culture and an investment on the part of government entities. And funding, of course, is also a critical element in really allowing for experimentation and implementation of more dynamic laws that are up to the challenge of adaptation. And I think on this note, I will conclude my presentation.
I think we have time for maybe 5 minutes of questions. If anybody has questions or comments on Lisa's presentation. And when you speak, could you please introduce yourself?
Sure. This is Grazia Borini, and yes, can you hear me? Yes. I'm wondering about the adaptation in the areas of protected areas. And you didn't notice it specifically, but it seems to me that you called for connectivity as a main methodology. Thank you so much. As a main pathway for adaptation in that case. And I'm wondering if maybe another pathway that could be interesting, specifically in the legal framework, would be the one of governance of protected areas. I wonder if you care to comment about that.
Yes, no, it's true. It's a very important element, particularly of the work of the Convention on Biological Diversity, that is part of the work program on protected areas, but we also see resurfacing in other areas, such as the Forest Biodiversity Work Program. And connectivity and governance are two very important elements that have to do with law and with implementation. And they very much link to the broader elements of ecosystem-based approach and involvement of indigenous and local communities and ideas of benefit sharing. In our work on the comparative perspective, I think what we saw is that while there exist examples of, for example, very extended network of protected areas, the role of governance is still one of the weak links, where most countries, developed and developing ones, appear to need for stronger legal regimes. And also what we see, which I think is quite interesting, some countries, mostly in the developing context, are experimenting on the ground with connectivity projects, but they have not yet created then the institution, not the institution, but the legal structure to then really make them a long-lasting approach to adaptation. And it may be useful to perhaps pioneer some measures on the ground and then decide how to build legislation, but of course building legislation should be an essential step, and that it's not necessarily where all countries are yet, not necessarily the stage at which they are all at.
Do we need a microphone? Thank you. It was a very interesting presentation. My question is perhaps a bit more general. I think you were very specific, but somehow when you tackle the issue of flexibility, which is inherent in the concept of adaptation, how can we? I mean, in general, because this is probably something that you will discuss in the course of the day, how can you reconcile this idea of flexibility in the law with the fact that law is per se inflexible in a way, and has to be for the sake of providing, certainty and security as far as what it regulates. So what is your view on that, especially in the context of the MEAs that you have analyzed and the issues that you have tackled in your investigation? Thank you.
And I think that's really the biggest questions in front of us as lawyers or as people that want to and need to work with lawyers. And there's certainly no, at least to my mind, there's no clear-cut answer to that. I mean, that is exactly what we have to discuss today and keep thinking in the decades ahead, I guess. Law is there to provide for certainty and clarity, and yet we have already realized that too much of that will not help us in our work towards adaptation. So the idea is how to inject some flexibility without completely overhauling what law is about. And I think some of the elements that I've mentioned in the context of the comparative work may provide some elements, but I think a lot more thinking is necessary to understand what are the pros and cons of each of them. So the idea of regulating by establishing objectives rather than specific obligations is a very interesting one. And for example, the EU has worked a lot in that direction in its context of its water law, saying, well, what the law asks is for you to achieve a good environmental status, and you have a flexibility in deciding how to achieve that. You have to create structures and procedures. I think in that case, for example, the procedures are the hard part of the law. So it is clear that you have flexibility in reaching certain substantive objectives, but then the certainty and the certainty is that you have very clear obligations in how to get to that determination in terms of the strict monitoring, strict participatory requirements, strict monitoring and feedback loops requirements. But there may be other, of course, other combinations. So we certainly have, I think this is very much the core of our work at the moment, and so there is some experimentation, but there's definitely a lot of learning that we still need to do about what works or not in practice.
Let's take 2 more questions and then we'll move on.
Right, Kofi Nguyen from Singapore. To answer Alejandro's question, he said that law is certainly how do we reconcile the flexibility that is required in adaptive measures. Here I think we should draw the distinction, particularly in environmental law. The soft laws, apart from hard laws, in fact the bulk of environmental laws include soft laws. And within conventions, many conventions in environmental law, for example, the CED, Article 6 itself, within the hard law, there are soft law provisions which call for planning strategies and so on. So here we find the element of soft law in the framework of hard law. And this is what I think the speaker said when she mentioned about strategies and all that. So it is not that, laws are always hard. Now the other point I want to bring out, you mentioned about mainstreaming various aspects into planning and all that. I would like to draw attention to the new phenomenon of eco-cities. And here, for example, Singapore is now partnering China to do an eco-city in Tianjin. And in Manchester, in England, the university is using eco-city. Of course, the term eco-city is not a technically good term. But in the context of climate change and so on, in fact, in Manchester, that there is a very interesting experiment. They are experimenting, and in fact, the whole of eco-city can be an experimentation of adaptation to climate change, and it brings to fore issues of climate change, biodiversity, transportation, energy, and so on. And I think we need to look out for this because up to now, eco-cities like Maastricht and other eco-cities in the United States, in France, they are all working in isolation. And I think there should be a move, and in fact social scientists are talking about the interconnectivity of eco-cities. And I think being a new phenomenon, one eco-city can learn from another eco-city. And this, I think, is a very interesting approach to adaptation to climate change, which links everything together. So you have, in fact, eco-cities like Tianjin, 30 square kilometers. It is, in fact, a salt marsh. And if you look into, in Germany, the Vorland was a military installation area. So out of nothing, it's like the phoenix rises. And to me, this is a very important experimentation. And questions will arise like, for example, the different countries will come together to deal with it. And it could be that should there be climate change, there could be whole populations of climate refugees, climate migrations. And these are ready-made cities that people can go to. And I think for adaptation of climate change, you have the short term and the long term. And for long term, I think eco-cities could be an answer, that you can migrate your populations to this part. And all eco-cities are very small. So they are manageable, and they are, to me, could be living laboratories for climate change adaptation.
Hello. I wanted to link back to your question. My name is Frederick Baron-Welch. I'm from the Center for International Sustainable Development, also one of the most students, I guess, that I'm here on behalf of the IUCN. I was reading a very interesting article recently on whether there needs to be a law of climate change adaptation, and the main argument that they were making was that law is stationary, and it kind of serves our interest because it's consistent and everything. But one of the difficulties is that the presumption of stationarity environmentally has collapsed. So we have law that is based on stationarity, in environmental cycles. However, we can no longer assume that. So we have laws that are fairly fixed, but the reality, the fact on the ground is now that it's no longer within stable boundaries. And so how do we have laws that recognize that we're no longer in these fixed parameters? So that still provides legal certainty, but at the same time. And so their proposal was to develop a law of climate change adaptation in a specific field of law. It was an argument whether there should be one or whether there shouldn't be one, so they developed kind of a conceptual understanding. The basis was that stationarity no longer exists, so how do we change our legal systems to recognize that? Because we still live in a land where everything's consistent and everything's the same, and we can expect that every year everything's going to be the same. It's like, that's not true anymore. So